I call Dennis O'Rourke.
Thank you, Mr Speaker. Now, we in New Zealand First accept that we have a rather novel situation here, and we also accept that it is not of the government's making. I've already criticised the Australian government for that, and I'm not going to go back there now. I've also criticised John Key for some of his behaviour over it. Again, I'm not going back there now. But I do want to say that I think that we should all see this bill as a starting point, and that there is going to be a journey after this to continue to deal with what is happening in terms of the returns of offenders from Australia to New Zealand, and that the bill will need review, and I'm glad to see that there is a review provision in it so that we can do that, because there are going to be a number of areas where there are provisions which may in the end prove to be inappropriate, or which are likely to cause problems, or which in fact prove to be unfair. I'm certain that we are going to see all of that happen within the next 2 years. But New Zealand First does accept that the matter is extremely urgent because of what the Australians have done to us, and because there are actually going to be very significant number of people returning from Australia to New Zealand, and that's going to happen within a matter of days. So we accept that this is a pretty good attempt at some legislation in the first instance, but we don't accept that it will be the end, and that the review will be necessary and changes will have to be made in due course. So we accept, we will support this bill, warts and all, because it is certainly better than nothing at all. Nothing at all would in fact mean relative chaos. So the urgency is obvious, and the need for some fairly comprehensive legislation is clear. This is better than nothing. It's not as good as I would have liked to have seen in terms of the refinement of some of the provisions, some of which I'm going to refer to in a moment. But it is saved, Mr Speaker, by Section 37, which requires the Justice and Electoral Committee to review the whole bill after 2 years and then to report to Parliament. And implicit in that is that the government will be willing to make changes. It doesn't say that. There is no actual commitment from this government, if indeed it is still here in 2 years, to make the changes which may be needed. However, I welcome the provision for the review, and I'm sure it will be taken seriously by all concerned. Now, Mr Speaker, New Zealand First does have areas of concern which I briefly referred to in my first reading speech. And one of those areas is Section 10. And Section 10 relates to detention by police for the purpose of identifying particulars. Now, Section 10.1 allows detention of an offender at any time within 6 months of return. And I wonder whether that provision actually is reasonable, because one would expect that if any action needs to be taken, it would need to be taken well within 6 months of an offender's return. So I raise the simple question of why so long? Surely that period is too long and ought to be reduced. And in fact, where people who have committed only obviously minor offences, then I think perhaps that there needs to be some way of sifting those people out so that they're not subject to the full rigour of what we see in Section 10. Because one of the other provisions of Section 10, subsection 2, refers to police detention for the purpose of identifying particulars at any times within 6 months, and, quote, a constable may detain an offender only for a period that is no longer than is reasonably necessary in the circumstances. Now, what on earth does that really mean? No longer than is reasonably necessary in the circumstances. It's actually a very wide power conferred on the police for them to judge how long that may be. And I would prefer to see a maximum period prescribed in the Act rather than to rely on such a wide and indefinite term. And Mr. Speaker, that's not the only issue, because we see in section 11 relating to how the particulars are taken, quote, in A, must do so in a manner that is reasonable, and in B, quote, may only use reasonable force to procure those identifying particulars. So there's a tremendous reliability on reasonableness and reasonableness of the police. Now, I think the police usually are very reasonable, but there are many cases which one could point to in which they have not been. So New Zealand First is a little concerned about the breadth of those provisions and the reliance on the reasonableness of police actions. Now, I accept that those particular provisions would probably only be used in relation to samples for DNA testing and not for other areas, but if that's the case, why isn't it restricted to just that? I don't understand why it is as wide as has been stated. And that's one of the areas that may cause difficulty in the future. So it's a concern to us, and maybe that's something we could discuss further in the committee stage of the bill. Now, the final area, Mr. Speaker, well, actually the penultimate area in which I wish to express some general concern relates to sections 26 and 7. And these relate to special conditions that may be imposed by the court, and the kinds of those are specified to be the kinds that are set out in the Parole Act. And having just reviewed the Parole Act, I think we can all be relatively satisfied that those are generally reasonable conditions. But I still suspect that the breadth and definition of this power for the court may actually cause problems. And the reason I say that is because the basis is in terms of events that have occurred overseas, convictions that have occurred overseas, circumstances that have occurred overseas, and I just feel that may lead to difficulties when it comes to imposing appropriate conditions. I do note, however, with some satisfaction that there are limitations on that. Section 26(2) says that a court may not impose a special condition for a longer period than the period for which the standard release conditions apply to the returning prisoner, and 26(3) says that the court may not impose special conditions unless it is designed to reduce the risk of offending, facilitate or promote rehabilitation and reintegration of the returning prisoner, or provide for the reasonable concerns of the victims of the returning prisoner. And those are well worthwhile provisions. But section 27(3) is an area of general concern. Again, nothing absolutely specific, but when you read the words in that subsection 3, it says, to avoid doubt, a court may impose interim special conditions on the information that is then available to the court, even though that information is incomplete or additional information is still being sought. So that power for the court to impose quite serious conditions on incomplete or unreliable information is for New Zealand First another area of concern. And it may be made without notice, but it will expire after a period of 30 working days. Nevertheless, I just express, Mr. Speaker, a general concern over that particular provision. And the last part relates to subsection 3, people returning after 6 months. There is some possible difficulty over that, in that a person must have been on some kind of supervision or something like an extended supervision order or a public protection order for the section to apply, and yet I still feel that there's room for concern that after 6 months, the ability to impose those conditions may not be appropriate.
I call Alfred Naro.